My name is Rich LaBelle. I'm Executive Director of Family Network on Disabilities of Florida, and I want to talk to you today about our presentation titled Planning is Crucial, Why You Need to Be on Top of Wills, Trusts, and Guardianship. This is meant to be a very practical presentation for persons with disabilities and their families to talk about the issues that surround futures planning, both for the person with disabilities and for family members. Now, the first thing that I want to touch on is that the overarching goals that we'll have for the presentation. First of all, we'll talk about the reason for setting up a plan. Why do you want to do this? The basic reason is that you want to set up a plan to try to avoid as many problems as possible for when you won't be here. For instance, if you're a parent of a person with disabilities, what you're trying to do is set up a structure so that when you're not around to run interference, when you're not around to do all of the things that you do now for free, to provide those natural supports, that you will have a plan in place that will minimize problems and ensure that your loved one with disabilities has the highest quality of life possible. You also want to involve the whole family in the planning process in age-appropriate ways and in ways that are appropriate for your family. Now, the reason for this is that even though your other family members, other children may have grown up with your loved one with disabilities, your child with disabilities, they probably won't have any clue as to all the things that you do for your child with disabilities and the reasons for that and the expenses that you incur and so forth. Before I took this job, I practiced law for almost 20 years. And when I was practicing, and still with the families who come to us as part of our trust administration program, what was very common was that those families would often say, okay, I'm going to leave all of my estate or a disproportionate amount of my estate to my child with disabilities. My other kids can fend for themselves and they can make their own way in the world, but my child with disabilities is going to need more resources, more help, and so that's the way we want to arrange things. For a lot of families, that makes perfect sense, and that's a very logical decision. But if you have other children, you don't want the first time that they hear that to come when they're sitting in a lawyer's office and he or she is reading your will when you're no longer around. You want them to understand up front not only what you're doing, but why you're doing it. Because again, what are you trying to do? You're trying to avoid problems. You're trying to head off problems. And I have unfortunately been involved in some very messy cases with siblings of people with disabilities who feel that they have somehow been shorted or treated inappropriately by their parents. And the big result is that money is wasted on attorney's fees, wasted on court costs. There are significant delays in distributing assets, and all of those things can have a very negative effect on the lives of persons with disabilities. So you don't want that to happen. You want to try to avoid that and, again, bring in the whole family into the process, and hopefully it will be a positive and family strengthening experience than simply talking about, okay, who gets what when mom and dad are gone. As you go through this process, I can't stress this enough, that it is important to understand the basics, important for you to understand the primary purpose of the various documents that you're going to be drawing up, the various strategies that you're going to be developing, understand why you're doing those types of things, but don't get lost in the details. And that's where people oftentimes struggle with future planning because they feel that they get overwhelmed. They get, a stack of documents with dense legalese put in front of them, and it's mind-numbing. Well, it is mind-numbing. You know, there's not a better cure for insomnia than reading, you know, a lot of trust documents or wills or estate planning documents. It's very, very dense language typically. You don't need to understand every single, you know, dash and dot and comma and period in that. You do need to understand the basic purpose of it and what the various provisions do. But don't get hung up on the legalese, and don't feel overwhelmed because of that. Ask as many questions of your advisor or your attorney as you need to in order to be able to understand those things, but don't get overwhelmed. Finally, for many purposes with planning involving a person with disabilities, keep an eye on the calendar, because 18 can still be a magic age in Florida for a number of reasons. And the primary reason for our discussion this afternoon is that 18 is the age of majority for most purposes in Florida, and at the age of 18, persons become legal adults in the state of Florida with all of the rights and responsibilities that all other adults have, regardless of what disabilities they may have, unless there is a guardianship action instituted. And we'll touch on that further as we go along. But keep an eye on that calendar, and as we'll discuss a little bit later, if you feel that some type of guardianship proceeding may be appropriate for you and your family, don't wait until your son or daughter turns 18 or after the age of 18 to start planning. Try to do it as far in advance as possible so that when they do turn 18, you're ready to go. Now, the first subject I want to talk about in terms of planning are what types of documents are you going to need for yourself and for persons with disabilities. The basic planning document is still a will, last will and testament, and this allows you to say to the world and to the legal system, this is what I want to have happen to my stuff when I'm no longer around. Now, I think it's a real good idea for people to be able to do that just as a basic policy matter. You should be able to decide what you want to have happen to your stuff rather than somebody else like a judge who may not know you, may not know your family, may not know anything about you. But if you don't have a will and you pass away and you leave property behind, which almost everybody is going to pass away in today's society and leave property of some sort behind, those decisions will be made, but if you don't have a will, they're not going to be made by you. Now, I just think it makes most sense for you to be able to do that. Now, it's especially important when you have a family member with a disability because by having a will, in the will itself, you can direct your property to go places and to a special needs trust, for instance, or to other places that will not result in disruptions to the lives of your loved ones with disabilities. Let me give you an example. If you pass away and you leave more than $2,000 worth of property for most purposes to your loved one with disabilities, you don't have a will, they get that property outright, and it can be any sort of property, it can be money, but they get that in their hands. For most programs like Medicaid or SSI, they will be disqualified. They will not be able to receive benefits. If they're receiving benefits already, they will likely get kicked off of those benefits. Well, that's a huge problem. You don't want that to happen. But again, if you don't engage in planning and you don't have a will and say, no, I don't want my property or my money to go directly to my child with disabilities, I want it to go over here instead. If you don't do that, then that's the kind of thing that can happen.